Hello, everyone. Thank you for joining Impact Group and Armstrong Teasdale for our Reduction in Force Planning webinar. My name is Ashley Ayers with Impact Group, and I will be your moderator today. If you experience any issues during the webinar, you can let me know in the chat box. You can submit any questions that you have for the presenters in the chat box as well, and we will have time at the end of the presentation to answer those. There are 3 handouts attached to supplement the presentation. You can access those at any time. Everyone is on mute, so now I will hand it over to Christy Nygaard.
Hello. We're happy you have joined us for this important webinar. Today we have a panel of presenters who will be talking about reduction in force planning, reducing risk, protecting brand, and championing your people. Our first speaker will be Dan OToole. Dan is an attorney at Armstrong Teasdale who has been practicing labor and employment law on the management side for 25 years. I myself will be a presenter. I'm currently the Vice President Business Solutions, partnering with clients to support solutions related to employee development and transition actions. Michelle Mortini manages over 200 outplacement coaches for Impact Group. She has a corporate background in outplacement, and she will share best practices for that perspective as well. This past week, our team sat in the office of a Chief Human Resources Officer. He shared with us that the company's CEO and Board of Directors were having to make a decision to change the business model of their company to respond to change in the marketplace, expectations, and technology. The impact of their decision would affect hundreds of employees in 5 different cities, and he wanted to discuss with us how to make a plan to the Board of Directors, which he is expecting to do in 4 weeks. He wanted a plan that would protect the dignity of each of his employees that would be affected by the downsizing. He talked about the effect of the brand and the remaining employees. He wanted to talk through each aspect. That is what we want to talk with you about today. We want to provide you with some things you need to be concerned about as you're planning a reduction. Throughout the webinar, we'll touch on the legal aspects and the risk of reducing staff, protecting your company's brand, empowering your separated employees, and minimizing the effect on stakeholders and remaining staff. So to begin, I would like to introduce Dan OToole, who will speak about Phase 1, making the decision, and things you need to take into account. Dan, the mic is yours.
Thank you, Christy. The first thing an employer needs to do, or one of the most important things an employer can do when making decisions in the context of a reduction in force, is to make sure that the manager mitigates the risk to the organization. In order to manage or mitigate the risk to the organization, you certainly need to understand the risk, and that is what I am going to talk about today. The risk comes from the framework of laws that are out there that impose obligations on employers not to treat employees in certain ways. State and federal laws all prohibit discrimination and retaliation in the context of a workforce reduction, and these statutes provide the avenue for employees to challenge employment decisions that are made as part of a reduction in force. One of the most important things to understand is that every employee in your workforce is a member of multiple protected classes as a result of statutes. There's Title VII of the Civil Rights Act of 1964, for example. That statute prohibits race discrimination, color discrimination, national origin discrimination, sex discrimination, or discrimination on the basis of religion. And when talking about Title VII, it's important to understand that that statute prohibits discrimination not just against women or females. It prohibits discrimination on the basis of gender or sex. So if you discriminate against a man in the context of reduction in force, it is just as illegal as if you discriminated against a woman. And the same applies with respect to race discrimination, national origin, or any other of the protected bases. You are prohibited from discrimination against minorities and also against the majority. There are prohibitions on age discrimination also, and that is found on the federal level by the Age Discrimination in Employment Act. Most states have state statutes that extend similar protections to employees from discrimination or retaliation on the basis of age. The Americans with Disabilities Act prohibits discrimination on the basis of disability and requires an employer to provide reasonable accommodations to a disabled employee in the workforce. And a disabled employee cannot be subject to discrimination or retaliation for either being disabled or for having requested a reasonable accommodation in the employment setting. There's a number of other statutes out there that also prohibit discrimination and retaliation against employees that are lesser known. The Uniform Services Employment and Reemployment Rights Act, commonly known as USERRA, protects members who are individuals who have served as members of the armed services from discrimination for having performed that service. The National Labor Relations Act prohibits discrimination or retaliation against employees who have engaged in concerted protected activity under the statute for their mutual aid and protection. The Family and Medical Leave Act is another example. That statute provides time off work for individuals with a serious health condition or with a family member with a serious health condition, or for the pregnancy, birth, or adoption of a child. And that statute prohibits discrimination against an employee or retaliation against an employee because that employee has exercised rights under that statute. There's a host of state and federal whistleblower laws. We know a lot of them, or we've heard of a lot of them, like the Sarbanes-Oxley Act, which protects people from discrimination or retaliation for having blown the whistle on improper accounting practices or other practices in the corporate setting. There are, in addition, a host of state and local anti-discrimination and anti-retaliation statutes. Almost every state out there in the United States has a state and local fair employment practices statute that prohibits discrimination. The bases of prohibited discrimination under those statutes vary widely, and so you need to understand the venue where you are operating as an employer and know what laws apply in those circumstances. So knowing now that all of your employees in your workforce are in the course are covered by various employment statutes, we know too that every decision made as part of a reduction in force is subject to challenge. Any employee who is chosen as a person who will be laid off in the course of a reduction in force has a potential claim against an employer if that employee believes that he or she was the subject of prohibited discrimination or retaliation. So what employers want to do when making decisions in the context of reduction in force is first to articulate the criteria for the decision. And I don't mean you articulate the decision to the entire workforce, but what you want to do is set out somewhere and decide, here is the basis upon which we are going to make decisions as to what employees are chosen to be laid off and what employees are retained. You want to make sure that that decision is clearly identified and the criteria for that decision is identified. And where possible, you want to use objective criteria as a basis for your decisions. And objective criteria might be, for example, length of service with the company or performance ratings on the performance evaluation form. You want to try to stay away, if possible, from subjective criteria, such as he has a good attitude or he is a team player. And the reason for that is pretty obvious, because when you're making a decision based on a length of service with the organization, where the employee who has been with the organization longer is the one who is retained, it's pretty easy for an employer to demonstrate whether or not the employer followed its own rules for how it was going to make layoff decisions. If, on the other hand, you've got subjective criteria, it's much more difficult for an employer to prove that it followed its criteria in making decisions based on good attitude. How do you prove, for example, that one employee has a better attitude than another employee? The other thing it's very important for an employer to do is to make sure that once it articulates objective criteria for the decision, that it applies those criteria consistently, because what you do not want to happen is to have a situation where you articulate, for example, that an employer will will select employees for layoff based on who has the least amount of seniority, and then have a situation come up where a person with lesser seniority was retained over somebody with greater seniority. So how does an employee prove discrimination if he or she believes that they've been subjected to discrimination or retaliation? There's really three ways that an employee can do that. The first and easiest is to provide direct evidence of intentional discrimination. And that could be, for example, statements made by decision makers that demonstrate an illegal animus. For example, if the president of the company says we need to do a reduction in force because we're way too old, we need to get some new blood in here, those types of things. Those types of statements are indicative of illegal animus against employees on the basis of age. And those types of direct evidence statements can be used, of course, to prove discrimination. The second way is indirect evidence of intentional discrimination. And the way an employee proves discrimination under a direct evidence method is by disproving the employer's articulated reason for the decision. So if, for example, you have an employee who believes he has been subject to discrimination on whatever basis, race, age, gender, that employee can prove discrimination by disproving the reason articulated by the employer. For example, if the employer says, we kept the people who were here and had the greatest tenure with the company, and this employee was let go even though others with shorter tenure were kept, that is how the employee disproves the employer's articulated reason. And the third and the most or the least understood way an employee proves discrimination is by what's called disparate impact analysis. And what disparate impact analysis is when you have a facially neutral reason for an employment decision, and the application of that facially neutral employment reason has a disproportionate impact on a protected group. So if you take a disparate impact analysis, you don't look at what the proof is and what the employer's intent was. What you do instead is look at the decision and you ask, how did this affect the workforce? And what the courts and the EEOC do in disparate impact is they use a variety of statistical analyses to show that the way the employment decisions were made resulted in a statistically significant disproportionate impact upon a protected group. If the selection criteria does produce a disparate impact, it doesn't necessarily mean that the end result is that it is illegal, but the employer then has a heightened burden to prove that the factor or the decision that was made was in fact non-discriminatory. So once the employer goes through and makes the employment decisions and determines what employees are going to be impacted by the reduction in force and what employees will be spared, for lack of a better word. The employer should look at the statistics, essentially, and determine whether the application of the selection criteria generated a disproportionate impact. And one thing you can do as an easy way, for example, is you can take and look at the average age of a workforce before the reduction in force and after the reduction in force. And if you have a workforce that was 60 prior to the reduction in force and suddenly the average age is 50 after the reduction in force, that should send off alarm bells that suggest that your selection may have resulted in an unlawful disparate impact. There's a couple of other statutes that apply in the reduction in force context, and the first one I'll discuss is the Worker Adjustment and Retraining Notification Act. It's called the WARN Act generally. And what that does is it applies to employers that have 100 or more employees, where an employer undergoes either a plant closing or a mass layoff. So we need to understand what those terms mean, plant closing and mass layoff. A plant closing is the shutdown of a single site of employment or a facility or an operating unit that results in an employment loss for 50 or more employees. And that employment loss can simply be a greater than 50% reduction in hours, and the employment loss for those 50 or more employees has to exceed 6 months in duration. So if the plant shuts down for 3 weeks during the course of the summer, that would not be a plant closing under the WARN Act because it did not satisfy the 6-month requirement. The other circumstances covered by the WARN Act is a mass layoff, and that's a reduction in force that is not a plant closing, but that results in an employment loss for 50 or more employees if those 50 or more employees constitute 33% or more of the workforce, or 500 employees. That's a little confusing, so I'll go quickly. So if you had 50 employees who were subject to a reduction in force, but you only had 120 employees, those 50 employees would not constitute one-third, or would constitute, one-third of at least one-third of your workforce, and so you would have a covered mass layoff under WARN. If, on the other hand, your 50 employees that were laid off out of a workforce of 250, that's not a third of your workforce, and so that would not be a covered mass layoff. It's important to understand in the context of WARN that there is a 30 and a 90-day look-back period, and what I mean when I say that is that WARN does not take a snapshot day by day of what the employer's activity is, but instead looks at that activity over a period of 1 month and 3 months to see how many employees were affected during that time period. And what this prevents the employer from doing, obviously, is laying off employees piecemeal in levels to avoid coverage, and instead what the courts and the Department of Labor do is they look at the overall effect of the actions when they occur within a 90-day period. So if you're covered by the WARN statute and you go through that analysis, what does that require you to do as an employer? You need to warn the employees, and the warning requires 60 days advance notice of the layoff. The notification in the case of a union represented employer needs to be given to the bargaining representative, the union. If there is no union involved, the employees affected by the reduction in force or plant closing are entitled to the 60 days notice personally. There's also a requirement that the notice be provided to elected officials such as a mayor of a city and the state dislocated worker unit, and that's usually a part of the unemployment office. It's important to understand too that that there are various state statutes out there which mimic WARN, but that have different threshold levels. So you want to check that if you're doing a reduction in force to make sure that there is not a state mini WARN Act out there that provides additional limitations on your actions. The last statute I want to talk about is the Older Workers Benefit Protection Act, and that statute essentially says that if an employer, in the context of a discharge of an employee, is going to ask the employee to release claims for discrimination or retaliation under the Age Discrimination Act, then there are certain requirements that the release the employee will be asked to sign must satisfy in order for that release to be valid. And it needs to be, there's about 6 or 7 of them, so I'll go through them quickly. First of all, the release needs to be written in what the regulations say is plain English. It needs to specifically mention the Age Discrimination and Employment Act. It needs to apply retroactively only, meaning that you can only release or require an employee to release past conduct, not future conduct. There must be consideration for the release, and normally that's just something of value. So you give the employee some money as a severance benefit. In exchange, the employee releases you from liability. The release, in order to comply with the Older Workers Benefit Protection Act, must also advise the employee in writing to consult with an attorney. In a normal one-person termination proceeding, the Older Workers Benefit Protection Act requires the employer to give the employee 21 days to consider whether to sign the release, and then once the employee does sign the release, the employee is permitted 7 days after signing the release to decide to change his or her mind and revoke the signing of the release. In the context of a reduction in force, and in the Older Workers Benefit Protection Act, that is an elimination program that affects just 2 or more employees. There are additional requirements that must be satisfied in order for the release to be valid. And that is that the employer must notify the employee as part of the release of the contours of the reduction in force. And so you need to describe the impact of the reduction in force by listing the job titles and ages of the employees who were selected for the reduction in force, and the job titles and ages of the employees that were not selected for the reduction in force. You also have to describe generally the decision-making process that went on in terms of what was the group of employees who were considered for layoff, what were the eligibility factors, and what were the time limits that the employer applied. And the obvious reason for this is that the government is telling us that before we require employees to release claims under the Age Discrimination Act, we're going to allow those employees to see a snapshot of how the reduction in force affected people by age and job title. The final piece of this in the context of a reduction in force is that when you have a reduction in force and you provide the employees with this additional information, rather than giving 21 days for an employee to consider whether to sign the release, the employee in a RIF situation is entitled to 45 days to consider whether to sign the release, and then 7 days thereafter to revoke. So that's a snapshot of our legal framework that we're dealing with in the context of a reduction in force. And with that, I will turn it over to Christy Nygaard, who will present the second section of our program here.
Thanks, Dan, for that very thorough and comprehensive explanation. I think you can all see the importance of having a counsel partner with you around the process of developing criteria, who you will include, and how you will manage the early part of the decision process. Once your business case has been decided and you know what your organization is going to look like, you've worked with counsel and your managers to determine who will be separated, then it's time to begin planning and preparing for the reduction. The approach we suggest is to create a separate plan for each affected group: your separated employees, your notification managers, your remaining staff, and your customers and the community. Let me talk about each one of these groups separately. When you're thinking about separated employees, you want to give them the dignity and respect they deserve as an associate of the organization. Keep in mind, all the retained employees are watching how you treat their former peers, the separated employees, throughout this process. You really want to give the separated employees the opportunity to move forward. One door is closing, but you want to give them opportunities for new doors to open. Prior to notifying the separated employees, you will first need to create the severance packages. Think about packages that have been offered before. Questions to ask include, how long will you provide severance? Will severance cover the entire notice period? Will it cover how long it typically takes to find a job? Companies usually provide severance based on the longevity of each employee's career, but they may also base severance on the level of the employee. In the job market, it takes an executive longer to find a position, so those packages are typically longer and include more robust outplacement programs. Next, you want to figure out what the notification date will be for each location and how the actual notification will be handled. Michelle will talk about the notification day in more detail in the next phase. Partner with your outplacement provider as you determine the transition services you will offer each employee. As I mentioned, you want to take the level of the employee into account when deciding this. It's important that your programs don't feel just like a Band-Aid. A Band-Aid approach would be giving everyone a workshop. In workshops, it's very hard for employees to feel that their individual situation is understood and addressed. Providing outplacement programs, personally assigned, dedicated coaches that can be paired with each employee based on their career, the more individualized your programs are, the better chance each employee has to move forward. And if your employee is moving forward, they aren't looking back on the number of factors Dan laid out in terms of what are the legal implications of the layoff. If employees are not treated with dignity and respect throughout the process, then unfortunately, they start to think, are there legal ramifications from this reduction for me to pursue? Another part of your plan should include the development of a questions and answers handout. Best practice is having 2 to 3 pages of questions such as, why me? What criteria was used to determine who would be let go? What benefits will I receive? So develop a few pages of questions to answer and address such concerns. Also, determine the last day each employee will work. Some companies say the day they are notified will be their last day. Other companies want to provide a notification period of so many days. Then there are others who need to transfer a particular technology or area of business over a predetermined period of time, and that will be the employee's last day. So think through when the last day will be and how the work will be transitioned, and then build your notification programs around those dates. If there is going to be a delay in the employee's last day, it's a best practice to provide their career transition or outplacement services right away. So while they are completing their work, they can begin focusing on something that is in their control. They've already lost control over continuing to work for your company. So they want to start feeling that they can take control of the next steps in their career transition process. You will want to select a career transition partner who will work with you to get the employee's outplacement support started early. That will get the notified employee thinking forward while helping all employees to stay engaged and productive during the notification period. The constant thought throughout this phase is, how can I treat him or her with dignity and respect? How can I get them to think forward to their next opportunity? You also need to decide if redeployment opportunities will be offered. When will it be offered? How long will it be offered? Some companies give employees a 2-week redeployment window. And one thing you want to consider with redeployment is, do you want to provide coaching assistance to help notified employees prepare their resume along with interviewing prep for new opportunities within your company. We've just touched on some typical areas to think about as part of your plan for separated employees. The next step is to create a plan for the notification managers, those managers who will be giving the actual separation notification. You will also need to determine the process for training managers how to deliver the notification message. How the manager communicates the message to the employee can make or break how that employee handles the notification. I've seen managers treat the separation like it was a performance issue, and then the person feels like they want to become defensive. They can become angry at the manager or the company. Managers need to make it clear that the separation is a business decision that is affecting one or more employees. The less personal the manager makes it, and the more they relate it to the business case and the criteria that was used, the better the likelihood the employee won't feel singled out. So training the notification managers is a very important part of your reduction plan. Training can be done internally, or you can bring in your outplacement partner or EAP firm to plan and provide the notification training. We will talk about the very important plans for the remaining staff when we speak about Phase 4. And finally, you need to create a plan for your customers in the community. That plan should be put into effect right away. Make your customers aware that there was a reduction in force at the organization. Ensure there is a plan in place in terms of who is going to tell customers verbally and how to explain how their accounts will be handled in the future. To recap, you want to build a plan for these 4 important groups. In Phase 3, we want to talk about the actual notification day. Michelle has led notification days on both the employer side and as an outplacement provider, so she has a lot of insight on the do's and don'ts when it comes to the notification day. Michelle, yours.
Thanks, Christy. As Christy mentioned, the Impact Group has seen really firsthand the impact that preparation can have in helping a notified employee move positively through the transition process. Proper preparation and a really clear plan for the day of notification, it's going to ensure both the notified and the remaining employees are treated with dignity and sensitivity. So as you're thinking through this and you're making your plan for notification day, you want to think through really all the possible contingencies, such as the employee being on vacation, someone being on short-term disability, someone being out sick on the day of notification. You also want to think through a plan for notifying any virtual workers that you might have. Having a plan to address all of these possibilities in advance will help you stay on target during the day of notifications. And as you prepare to go into your actual notification meetings, just remember that you want to communicate some basic ideas during the meeting itself. You want to communicate the warning and rationale, and that's really just setting the stage, providing the business case. You want to deliver the message clearly. Explain separation support. You definitely want to be listening and responding with empathy, but then also think through providing structure for the next steps, and also think through having a very clear closing for the meeting, encouraging the employee to take those necessary next steps. A lot of HR leaders also tell us that as part of the planning, you want to take into account any special circumstances. Is it someone's birthday? Is it their anniversary? Have they gone through a recent life-changing events? In addition to these milestones, you also want to be mindful of when you schedule your notifications. So, it's really a best practice to conduct the meeting itself Monday or Tuesday if at all possible. Notifying early in the work week, it gives the notified employee time to act on getting additional information on benefits such as COBRA, outplacement support, even talking to EAP. And most experts agree that you really shouldn't wait until Friday. This ensures that the separated employees can take positive steps towards launching their job search, but it also gives you time to communicate quickly with your remaining employees, giving them time to process while you communicate a plan to address workload. And you also want to consider where physically to conduct the meetings. If possible, be sure to select a neutral conference room. We don't recommend that you use your own office or even the employee's workspace to deliver the message. You know, delivering in your own office, it may seem like the most convenient way to do this, but it definitely has some drawbacks. You know, some individuals may lose their composure when they're notified, and you might find it not only awkward but inconvenient to step away from your office while you wait for that employee to regain his or her composure. And you certainly don't want to notify in someone's personal workspace because of potential privacy issues or, you know, just honestly the likelihood of embarrassing that employee in front of their peers. So, you know, select a neutral location and try to visit the notification space in advance. Think through simple things like, are the chairs in an informal or comfortable seating arrangement? Will there be a glare or bright sunlight in the room? You do want to avoid having the employee sit so that they're facing into a glare. If there are inside windows, is there a covering, blinds, or something to maintain the privacy of the meeting? And if you're notifying by telephone, try and arrange with, you know, a peer HR professional or a senior manager at that facility to ensure that whatever conference room the employee is taking the call in provides them with privacy. And of course, you always want to partner with someone who's at least at a higher level than the employee being notified. But, you know, in the physical space itself, you want to make sure that the room is supplied with a box of tissues, you know, a pitcher or glasses or bottles of water. You know, these little things can be great equalizers. Taking a tissue or even just a drink of water can help someone regain composure. And as part of location planning, you also want to consider how you're going to handle allowing that employee to collect his or her personal belongings. And finally, beyond the logistics of notification day itself, you also really want to take some time to prepare yourself and your notifying managers to appropriately respond to the reactions of notification. And, you know, while reactions to notification are going to be as unique and diverse as the individuals that you'll notify, there are typically some fairly predictable reactions, including denial, shock, anger, and acceptance. And you may see an employee's initial reaction move from denial, shock, or anger all the way to acceptance just within the space of a few minutes. The majority of notified employees will typically demonstrate acceptance, but I think regardless, being comfortable with your notification message, it's going to help you respond appropriately. However, you know, we always do say if you feel like there's a potential for a hostile response, you do want to have a plan for having security on standby, you know, down the hall, definitely out of sight, just so you know that we're there. Now, I'm going to pass the mic back to Christy, who will cover Phase 4, Leading Company Recovery. Christy?
Thank you, Michelle, for discussing Phase 3. Now let's look at Phase 4, which focuses on your remaining employees and leading your company forward. I'm not going to cover a lot of details in this phase. I want to give you a couple of key points to think about. The first thing is to communicate to the remaining staff immediately. So after all the employees have been notified, you want to have each manager arrange a meeting time in their own area and explain to their team members the business case for the reduction decision. Share that the separated employees are being provided transition support to help them move forward, and that it has been a hard day for everyone in the company. Acknowledge the hard work the remaining employees have all put into the company. Let the employees know you are sensitive to the fact that the separated employees were all important colleagues to their team members and will be missed. Then communicate the company's or department's plan for going forward. It's important to have regular meetings with the employees as well. It's important to have one-on-ones with your star performers. Treat the conversations as you're recruiting them all over again. So have a plan for each of them to help them understand their value and to help maintain engagement and productivity. We also suggest having your outplacement partner facilitate going forward, or what's often referred to as survivor workshops for all remaining employees. These workshops are typically delivered in either 2-hour or half-day sessions for managers and retained employees. Usually there is a time allowed for grieving the loss of their colleagues. There's segments about change and managing change, and there's segments about the work going forward. The Center for Creative Leadership has done research that indicates the employees who remain have substantial grief related to the employees who were separated. Survivor workshops can address ways to handle the grief process. We highly recommend providing these workshops, and when offered, you can expect to improve the engagement rate and experience a faster return to productivity. And something that is important to focus on during this whole time is transparency. Management should be visible and should be with the employees. If you have a particular location or group that has been affected, it's important the manager be visible there. Have one-on-ones, talk the issues through. Reassure them the separated employees are being provided with services that will help them move forward. Hopefully, as you've listened to this webinar, it's given you different thoughts to consider when planning your reduction. Please feel free to contact Dan OToole or myself if you would like to have further conversations about reduction in force planning and support. We do have some materials we want to share with you, including a reduction in force planning checklist and a manager notification checklist. Those are included in the handout section of the webinar, and we will also email you copies in a thank you email. At this time, we'll take your questions. You can send those to Ashley in the chat box. Ashley, do we have any questions?
Yes, the first one is for Dan. The question is, do you see fewer litigation issues when employees are given a notice period versus an immediate effective date?
That's a good question. If I don't know that I've ever analyzed it that way as to whether you get more litigation or employment issues when you give lots of advance notice as opposed to an immediate decision. The answer to that question, I think, depends upon how sound your decision is. So if, for example, you give lots of advance notice of the decision and the employee therefore has the opportunity to remain in the workplace and gather information, if your decision is sound and supported by the other employees, then certainly that will go a long way towards leading the employee to believe or having the employee understand that the decision was not in any way discriminatory or otherwise improper. On the other hand, though, if you have a workforce where you've got a lot of people who talk and there are conspiracy theories out there, you can see where there might be a situation where leaving the employee in the workforce after the decision is made might only work to trigger claims.
Okay, great. Thank you. The next question is for Christy. What time frame do you typically recommend for starting phase 1 or 2?
Well, that's a great question. Planning for a reduction in force, well, that may never happen, is pretty similar to disaster planning. So now is the time to ensure managers and leaders have a solid understanding of state and federal laws. HR and executive leaders should talk through scenarios related to individual department layoff needs, in addition to outlining steps you'll need to take. Information you'll need to have in order to determine which jobs and employees would be impacted in the event of a business need to reduce staff. Some teams go as far as to create a case study and follow it with a disparate impact analysis to identify gaps in their process. As for phase 2, teams can greatly reduce HR and leadership anxieties when the need for a reduction in force is identified by developing plans for each of the 4 groups right now. I often work with HR teams to develop their plans related to redeployment, manager notification training, determine your outplacement programs to meet the current needs, and identify what type of survivor workshops will most likely be offered. I'm often called upon to help teams review their plans annually so the HR teams and executives understand the changing job and transition markets and they can plan accordingly and modify as needed. So I say it's always better to be prepared than to hope you'll never need to plan and implement a layoff.
Great. Thank you, Christy. And the last question we have would be good for Michelle. It says, we have a number of employees working out of home offices. What do you recommend to handle those terminations?
That's a really great question, and I think it comes up for employers more and more frequently these days. I think a lot of the things that we talked about today still apply to a virtual workforce. You've got to approach planning for communicating with them. I think sometimes where we will see, perhaps difficult decisions come into play is when an employer has to decide if they want to just notify virtually via phone or via web session, or rather if they want to require an employee to come into a physical office. And sometimes if an employee has to travel a great distance to come into a physical office, that may not be the best approach for that. So I think just still communicating all of the things that we suggested in the meeting, understanding that it may have to be a phone call instead of a face-to-face meeting, and then following up with anything that you can in writing immediately afterwards. It's going to help that employee positively process that message and know what they need to do to go forward. And then, of course, you still need to communicate with your remaining workforce as quickly as possible, because someone could be online sending messages while you're having that conversation. So you've got to have a plan to address your remaining employees very quickly afterwards as well. Great question.
Okay, and the next question says, we have what is the best way to handle work-at-home employees as far as WARN tracking? What location should be used?
Well, I can address that. The WARN regulations contain specific provisions that help you determine whether an employee is counted for purposes of a reduction in force. And specifically what those regulations say is when you've got employees who are scattered and working at different places of employment, maybe virtually working at home, what the regulations do is to assign that employee or treat that employee as if that employee works at the place into which that employee reports. So you follow the reporting structure. And the office that houses the person into which those employees report will be counted as the location of that employee.
Great, thank you, Dan. That is the last of our questions, so I will hand it back to Christy.
Okay, thank you, Ashley. Thank you for attending today's webinar. Both Armstrong Teasdale and Impact Group would love the opportunity to partner with you as you are faced with developing and implementing important strategies for your company. You will find contact information for Dan OToole and myself at the end of the presentation. Have a great day, and thanks for joining us.